that me? That's my name.
Oh, you should have the one.
Yeah, no, it doesn't. They have the names mixed up here. All right. I'd like to begin by getting a list of people who wish to make a presentation to this group. Okay. Would you stand and give us your name? Okay.
Trisha Ward.
I'm sorry.
Trisha Ward.
John Hogue, Your Honor.
John what?
John Hogue.
Oh, yes. Okay.
Yes, sir. H-O-G-U-E.
After you said it, well, after I heard it clearly, I remembered how to spell it.
Brett Brunson.
Okay.
Deirdre Fuller.
Michelle Andrepont. Jean Feria.
Nathan Fennell.
I'm sorry.
Apologies.
hadn't caught
Nathan, and last name's Fennell. Fennell.
Okay.
Jim Boren, B-O-R-E-N. Afternoon, all of you.
Jacob Longman, Longman.
That's it? Okay. All of you who said you wish to speak, I think I have similar interests. Have y'all discussed what order y'all would like to proceed in? Okay, then go ahead and start. And again, repeat your name when you come up.
Sure. Good afternoon. Sit, stand.
You can sit.
Thank y'all. All right. Good afternoon. My name is Trisha Ward. I've been a public defender since 2008 when I graduated from LSU Law School, and I have served as a district defender in Evangeline Parish since 2021. We are here today to evaluate new information not available to this committee when it met on April 7th, 2025. Specifically, I'm going to walk through the relevant statutory framework and how the legislative actions in May of 2025 inform this board's current decision. LARS 146B1 makes clear that this board has the duty to provide supervision and oversight to the Office of the State Public Defender. The State Public Defender, that is the foundation of your authority. While the State Public Defender has authority to contract, that authority is not unlimited. It is subject to the constraints imposed by the statute. Mr. Storns has cited 15152B5 in his brief for a general power to negotiate contracts for legal services. But that statute does not govern district defender contracts. Instead, RS 15161A governs district defender contracts, and it says that the office shall contract to provide for the delivery and management of public defender services in each judicial district. That distinction matters because 15161 also has a provision a couple of paragraphs down, H1, and it makes clear that the legislature valued continuity in the management of district offices when it states, in an effort to maintain the continuity of public defender and services in each judicial, that should be district, any person serving as the district public defender of a judicial district shall continue to contract with the office and serve as the district public defender of that district.
I have a question.
Sure.
Now, it's your position that that provision goes on forever? It was not just a transition from the old system to the new system?
Thank you for that question. Mr. Storns has argued, and I believe this is what you're alluding to, Judge DeMahi, that provision was for 1 year. But that's not what happened in the legislature. There was a 1-year provision that was put in on February 20th of 2024 in the Senate Judicial B Committee. Senator Kuzan, after hearing concerns that perhaps the compensation of the district chiefs was going to be cut, made a decision to offer an amendment to protect our salaries. It had nothing to do with H1 at all. It was just to protect our salaries for a year while it gave this board time to establish a compensation plan by which we would be paid. So the amendment, there was an amendment later, 9 days later, exactly, by Representative Bacala on the floor of the House, and he amended 161H1. So before this last special session, it's this provision said, in an effort to maintain continuity, any person serving as the district public defender as of January 1st, 2007. He removed the 2007 language from that. And what he said when he did that was, I've been talking to the district defenders. They have some concerns. And in an effort to basically give us stability, his quote was, I'm going to take the 2007 language out. And so if you're a district defender today, you're a district defender tomorrow.
And forever?
Not forever. If in fact Mr. Storns alleges just cause and he does that in good faith, 100% we can be removed. But they were concerned about instability in the system with all of the changes that were occurring, and in order to provide and maintain and ensure that we would continue to have statewide functioning legal systems where dockets were moving and people were getting represented and all the things that the stakeholders care about, they wanted to make sure leadership was stable. Anything else? Okay. So in short, the legislature had emphasized continuity and stability in district leadership. I want to then turn to 15162. That provision defines when a vacancy in the position of a district defender occurs, and there are only 5 times that the statute envisions a vacancy in the position of a district defender: demotion, termination, retirement, resignation, and death. Non-renewal is not listed because it had not been contemplated, and that's significant as well. All of us here know that when a statute is silent, we look to the legislative intent. That intent was made explicit during the 2025 legislative session, and I believe things that occurred during that session are largely why we're here today. This past spring, Mr. Storns proposed 2 bills, including one, House Bill 447, that I have a piece of, where he attempted to insert non-renewal into the statute. Because you can look from the beginning of the statute to the end, you will never see the word non-renewal. This attempt by Mr. Storns mirrors what he has repeatedly done with compensation in this board. He continues to raise compensation at board meetings after it's been voted down because he knows that the current contracts he's proposed violate the law. And he attempted to insert language about non-renewal into the statute, explicitly barring appeals for non-renewals of contracts, because he knows what he's attempting to do right here is also not allowed under the statute. There'd be no reason for him to introduce this bill with that language if he thought that he had the right. And we know that he knows that the board reviews non-renewals of contracts because he said it himself. When testifying about the bill that became law last year, right here. Mr. Storn said, and I quote, "There are other roles for the Public Defender Board in Senate Bill 8, particularly in regards to when contracts are not renewed or whatever." And the reaction of the legislators last month in May when Mr. Storns attempted to pass two bills said it all. I want to look again at what the legislators said in that hearing on Bill 447 and 516. Representative Bacala, what we did last year is we said, yes, we're going to allow these contracts to not renew when it's for good cause. And the appeal would be to a board that would be able to review. And I think we have some cases under review right now. He realized, as did everyone else in that room, that you all were reviewing these terminations and that Mr. Storns was attempting to introduce a bill that would completely take away that power to do it as these cases were being reviewed. And in large part, that's why you saw some of the later quotes. Representative Knox, Storns gave his word last year that all the allegations that you guys are making here today would never come to light. And yet you sit here today, and it's exactly almost verbatim of how y'all forewarned this committee. Representative LaFleur, last month, I was making the same sort of observation that Representative Knox was making, and that is Mr. Storns is not in the room to defend this power grab because it's nothing more than that. This board's oversight role is clear. The statutes are clear, and the legislative intent is crystal clear. What is being attempted here is outside the scope of lawful authority, and I urge this board to hold firm in its duty to supervise and not simply ratify actions that are running contrary to the law and the legislative will. Please find that Mr. Storns failed to assert just cause, and thus he shall continue to contract with me and my colleagues. Thank you, and I will answer any questions at this time.
Any questions?
I just have one. What is the status of the bills?
They were both voluntarily deferred by the authors, so their dead session is over, but they were never even brought back. Representative LaFleur had actually moved to involuntarily defer the bill, then out of respect for the author, gave the author of 447 an opportunity to do a voluntary deferral. So they were both voluntarily deferred. The one that followed House Bill 447, the author chose not even to make a presentation. He got up to the table and said, "I'm voluntarily deferring." And the author of 447 apologized to the committee for bringing the bill.
Thank you.
Thank you.
Good afternoon. I would ask, before I begin, I would just ask that the committee take judicial notice of our comments that we made to the board at large just a few days ago and incorporate them into your, to the record.
Okay, introduce yourself again.
Yes, Your Honor. My name is John Hogue. That's Hog with the UE, or Hogue like Vogue. So Hogue. Yeah. So good afternoon. My name is John Hogue. I'm here today with my wife of 35 years, Luba, and together we have 3 beautiful daughters and 1 handsome son. Needless to say, they get their good looks from their mother, so I can't take any credit. I've been a public defender for over 27 years. For nearly 24 years, I served in the 22nd Judicial District, which is St. Tammany and Washington parishes, handling everything from juvenile, sink, misdemeanor, and felonies. At present, I've served over 3.5 years as district defender in the 6th Judicial District. It's a rural district in northeast Louisiana that includes Madison, East Carroll, and Tensile Parish, which is where I was a child. I represent a rural district, a poor district with deep challenges. Substance abuse, mental health, poverty, exacerbated by a lack of basic resources such as transportation, treatment centers, and jobs. But progress is being made. For instance, I was one of the first district defenders to secure opiate settlement funds, money that we now use to support our drug court attorney. More recently, I visited the construction site for Meta's new $10 billion investment in North Louisiana, a historic project and investment for North Louisiana. That's in the adjacent parish to Madison Parish. I've already met with Meta's representative, Henry Thornton, who you may recall was introduced by Governor Landry at the beginning of this session. I see a real opportunity for partnership with Meta that could transform one of the poorest districts in that whole region in Northeast Louisiana. I'm excited about that. And that's why continuity of leadership is critical. Louisiana law recognizes this need. RS 15161H1 provides, and I quote, "In an effort to maintain continuity of public defender services in each judicial district, any person serving as the district public defender of a judicial district shall continue to contract with the office and serve as the district public defender of that district." This law ensures that public defense leadership remains stable, allowing us to build long-term relationships with judges, sheriffs, police juries, district attorneys, legislators, and even private enterprise like Meta. Being a public defender is like a marriage. It takes years of commitment, trust, and hard work to succeed. Remy Starnes does not have the discretion to ignore the law. He must, as the law states, continue to contract unless there is a vacancy due to demotion, resignation, termination, retirement, or death, as outlined in RS 15162. Our district defender contracts must be continued year after year unless, as provided in RS 15161H, unless terminated for just cause, as outlined in RS 15170. No just cause has ever been alleged by Mr. Starnes, and none exist. Finally, RS 15146B1 states that the Public Defender Oversight Board is, quote, "created and established to provide supervision and oversight to the Office of State Public Defender." Supervision and oversight. As a board, I urge you to do just that. Exercise your supervision and oversight and insist that Mr. Starnes follow the law. Thank you.
Any questions? Thank you.
Thank you.
Good afternoon. I'm Brett Brunson. And I should say right now, before I forget, if you have any questions, stop me at any time and ask me. I'll be glad to give you any information about my district or how I run it, anything about what's been going on there for 18 years. So I'm the chief in the 10th District, Natchitoches Parish. I've been an attorney for 45 years, a trial attorney all that time. I'm not going to repeat what I said yesterday because I know you heard me. So I'm not just a leader in the 10th. I've also been a leader statewide, first regionally, and then in 2015 I was elected president of the Louisiana Association of Criminal Defense Lawyers. So I've served as a board member and all the offices of that association as well. I'm still on the board with a lifetime membership. I was the first district defender hired under the reform of Act 307 of 2007. Gene Faria recommended me for the board, and Jim Boren, who was a board member at that time, asked them to unanimously approve my hiring and my salary, which they did. Remy Starnes also happened to be a board member then. On that day that they hired me in 2008, they told me to come back and tell the board anything that I needed and anything that I thought that might improve what we do. And I said I would be glad to do that if you promise not to kill the messenger. And so I'm here today asking you not to kill the messengers that stand before you. Remy Starnes is refusing to follow the law. He's openly ignoring the compensation plan that was approved by 2 boards. He's forcing district chiefs to sign contracts that contain unlawful terms. He's circumventing board approval of funding of capital defense by running it through the districts, which are actually prohibited by law from spending funds outside the boundaries of each district. He's defunding Louisiana Appellate Project, a successful resource for all the districts to handle appeals of non-capital cases, and he's replacing it or defunding it without a successor in place. He says he will keep trying to get rid of any board oversight and keep trying to get rid of the board. He admitted that much on Monday, and you all heard him say it. He's trying to get you to abdicate your authority to oversee and supervise him. He is trying to get you to ignore the law too. The only issue before you today is, does the new evidence regarding the legislative intent and the enactment of Sections 161 and 170 of the Public Defense Law give you a reason to reverse the committee's earlier recommendation and to recommend that Starnes be required to continue our contracts? Now, the legislative history is being described for you by my colleagues. Tricia just went over it all thoroughly. In short, Starnes tried to amend the law just a few months ago to get rid of those protections for us. Representative Bacala recently said that his amendment last year protected us. Representative Knox said that Starnes is now trying to do exactly what he told the ACJ committee last year that he would not do. Remy Starnes admitted that this was subject to the requirement of showing good cause. That makes his decision reviewable by this committee. The law is in our favor. Starnes did not allege any cause for the letters he sent to us. They didn't state any cause. He has not stated any since then. Lacking good cause for his actions, the action should be overturned. Disparate treatment of women and minorities should not stand in this system. The law requires our contracts to continue. Thank you. I'll be glad to answer any questions.
Any questions?
Thank you.
Thank you.
No.
Good afternoon. My name is Deirdre Fuller, and I know you heard my testimony on Monday at the board meeting. I'm the Chief District Defender in the 9th JDC. I'm the first African-American female chief in Louisiana and the first woman to hold the position in Rapides Parish. I have established relationships with national organizations such as the National Association of Public Defenders, the National Association of Criminal Defense Lawyers. I have been a board member of LAP, the Louisiana Appellate Project, for almost 8 years. I'm committed to the public defense system. After 9 years as the district public defender, the state public defender has decided not to continue my contract, though the law provides that he is required to do so. Specifically, 15161H1 states, as you've already heard, in an effort to maintain continuity of public defender services in each judicial district, any person serving as the district public defender of a judicial district shall continue to contract with the office and serve as the district public defender of that district. Simply, if you are the district defender today, you are the district defender tomorrow, absent good cause. The law does not say may continue. It says shall continue. No one must be allowed to sidestep the law, including the state public defender. Because the state public defender knows exactly what the law says, he went back to the legislature last month in an effort to change the law and to get rid of this board in the middle of this process. Though he labeled it a cleanup job, it was in essence an attempted clean out job of this oversight board. But the ACJ committee read the tea leaves, and the bill's sponsors voluntarily retreated and apologized for bringing those bills. The law goes even further. As previously stated, 15162 provides that district vacancies only occur due to demotion, resignation, termination, retirement, or death. So why are we here? We exercised our right to oppose Senate Bill 8. We testified against it before the House Administration of Criminal Justice Committee in February 2024. The bill's main purpose was to eliminate the prior board and to concentrate as much power as possible in the hands of the state public defender, and that is exactly what it did. But because my colleagues and I testified to challenge the wisdom of that decision, the legislature opted to create this oversight board. Our contracts were not continued because we opposed the state public defender's maltreatment of certain female colleagues and pointed it out to prior board members. These are our crimes. For that, our contracts have been arrested. For the code of the state public defender, our penalty is to be not continued. If we are convicted, we will lose our careers. Personally, if I am convicted, I will be denied the benefit of some of my counterparts who have held contracts for decades and have been chiefs for 20 plus years. What they will enjoy is a retirement. I will be denied the benefit of the 1 year that I need to vest in the parochial employees retirement system in my office. I will be denied the benefit to participate in the DROP program for the required 36 months to enhance my retirement fund. I will be denied the right to a retirement to support myself after my work life ends. I worked for it. I earned it. It is mine. We do not seek more than the law provides: a statutory right to continue our contracts when there is no just cause or good faith to end them. Much to the state public defender's chagrin, you have the oversight authority and the obligation to follow the law. Do you have any questions?
Any questions?
I do have one question.
Yes.
How many years was your predecessor in office?
I had two predecessors. I'm the third in my district. The very first person to hold my position was there for 24 years. The second was there for 2 years. Thank you.
Good afternoon. My name is Michelle Onderpont. I was admitted to the Louisiana Bar in October 1992, and I joined the Caddo Parish District Public Defender's Office in October of 94, where I have remained until today. I've spent over 30 years defending the constitutional rights to counsel and fair representation. Today I speak out because Mr. Starnes is attempting to remove me and my colleagues. We're not surprised. We warned the legislature that this would happen when he sought to have control shifted from the board to him. In response to those warnings, the legislature acted in 2024, giving the board and this committee the authority to review such actions based on this 15:146B1, providing the supervision and oversight, 161H1, providing for continuity in district defender services, 162, providing that vacancies don't occur with what Mr. Starnes has called a non-renewal, and in 170, which provides our rights to this hearing. During the SB 8 hearings last year, Mr. Starnes acknowledged the board's role in reviewing non-renewals. Ms. Ward pointed out his quote, "There are other roles for the Public Defender Board in Senate Bill 8, particularly in regard to when contracts are not renewed or whatever." Mr. Starnes knew then, last year, that we had a right and the board had a right to review non-renewals. Representatives Villio and Bacala also made it clear The intent of the amendment provided by Bacala was job continuity, not temporary employment. Representative Bacala said, as Ms. Ward indicated, if you have the job today, you got the job tomorrow. Mr. Starnes now claims that those protections were just for 1 year, fiscal year 25, this current year. That's false. His interpretation of that relies on a note, an amendment that was offered in Jude B on the Senate side early on by then Senator Cousin. That language is not included in the statutory language about the continuity of 161H. It's not included anywhere. It is a note. As Ms. Ward noted, that amendment by Cousin was offered up on February 20th. The amendment by Representative Bacala was offered on the House floor on February 28th, well after the amendment that Cousin had presented. Representative Bacala stated then that he was doing so, offering the amendment, because he didn't believe the earlier amendments went far enough. And Representative Villio reiterated that when she was closing on the bill on the House floor. He also states in his brief that the Bacala amendment failed. That's blatantly false. That amendment is in the law. You can see it in 161H1. It's right there. It's in the code book if you go look at it. It's there. It did pass and was adopted and made a part of the law. And the legislative history on that shows that the final amendment from Bacala was meant to go further and to protect us more than Cousin's amendment. It came after that amendment and it went much further. Not less protection, but more protection. So, there's no question as to what the legislature intended. In fact, this year, when we appeared in ACJ, the Administration of Criminal Justice, regarding this year's House Bill 447, Representative Bacala followed up on his intent again, just this past last month, and said, what we did last year is we said, yes, we're going to allow these contracts to not renew when it's for good cause. And the appeal would be to a board that would be able to review. And I think we have some cases under review right now. Our cases are the ones under review right now. As Ms. Ward said, Mr. Starnes was trying in the midst of this process to do away with our rights while we're in the process. The legislature and the legislative intent is very clear. They gave you the authority to act and to review removals of district defenders to ensure that they were done in good faith for just cause. As my colleagues have stated, Mr. Starnes has alleged no cause. We each received a one-sentence letter informing us that our contracts were not being renewed. This year, in fact, was Mr. Starnes' third attempt in 5 short years that he's been the state public defender to centralize control and to weaken the public defense independence. Last month, when we all appeared, as you have heard, Representative Knox asked Ms. Fuller, aren't you the same 5 who were here last year warning us that this was going to happen? You predicted this exact outcome. We did. And now we're here, living it. I've opposed each of the 3 times Mr. Starnes has attempted to seize power for himself because I believe in a public defense system based on independence, accountability, and justice. And I submit to you that this isn't just about the 5 of us. We call ourselves the DD5. This is not just about the DD5. It's about protecting all those who speak truth to power. It's about the 5 of us having the courage and the audacity to speak up and to speak out when we disagree with a policy or a proposal. As public defenders, that's not just our responsibility, that's our duty. We fight injustice all the time. We just happen to be fighting for ourselves this time. This is about whether public defense will remain independent or we will become even more politically controlled. I'm proud of my service as a public defender, and I may lose my job, but I will not lose my voice, and I will not lose my integrity. I urge you to reject our terminations, to stand up for us, for justice, and for the defenders who will follow us. I'm happy to answer any questions you have.
Any questions? No, thank you.
Thank you.
Members of the committee, my name is Jacob Longman. My partner, Catherine Jackie-Back, and I are standing in for Stephen Hidicki and Rick Schroeder on behalf of the district defenders. At this time, do you guys mind if we take a 10-minute recess, or a sharp 10-minute recess?
Okay.
Thank you, Your Honors.
Something has to happen over there.
All right, good afternoon. My name is Jean Feria, and just to tell you a little bit about me, I've been a public defender for over 40 years. I first started out in East Baton Rouge Parish, and then I became the head of the Louisiana Indigent Defender Board at the Supreme Court, and then I became a federal public defender, and became, after that in 2008, the first state public defender under the original Act 307. I was on the American Bar Association Standing Committee on Legal Aid and Indigent Defense for 6 years, the oldest standing committee of the American Bar Association. I was a member of the Board of Directors for the National Legal Aid and Defender Association for 10 years, and I chaired that board for 2 years, and I'm a founding member of the National Association of Public Defense. And along with Mr. Boren, I am a founding charter member of the Louisiana Association of Criminal Defense Lawyers. And I'm a member of their Public Defender Committee. I spent time with Robert Spangenberg going across the country evaluating public defender systems and offices throughout the country, and have some background in public defense. And I wanted to share with you, in addition to my comments that I made at the board meeting regarding the contracts and the history of the contracts in Louisiana under the Public Defender Board, the aegis of the Public Defender Board, that we didn't have them for a long period of time. I won't go over all of that testimony. I'm sure you heard it, and I'd adopt it in the event that it doesn't make its way. I would adopt that testimony, but I also spent time researching, because public defender systems do change over time. I went back and looked at those states where we have gubernatorial appointed state public defenders only, without commissions. And I know that there have been a lot of statements about this board not feeling comfortable with the amount of power it has, but I would submit to you that the terms supervision and oversight that I mentioned to you at the March board meeting, those are strong words and they mean something. But despite that, I want you to be aware that the following states have gubernatorial state-appointed public defenders without commissions: Iowa, Rhode Island, Montana, Vermont, Alaska, Delaware, Idaho, New Jersey, and Wyoming. But they are very different. And the big distinction in this instance is that every one of those line defenders are state employees with the protections of civil service. In other words, the only way that they can be removed is if there is a just cause showing and that there is a due process hearing. So there is no other system in the entire country that allows for what has been presented to you. And I think you should take that into account when you make your decision, this very important decision. And I'm going to go back to a thing that there are two things that I want to repeat. One is, when I first appeared before you in March, I asked you, why doesn't he want you to know? What is it that he does not want you to know? I just simply cannot understand that. And the reason that I cannot understand it, because I sat in that position and I know how important it is that when one makes a decision like this very important decision, the rest of the defenders look at the behavior to determine, what should I do? You know, what did they do that got them to lose their jobs? And the only thing, as I told you on Monday, the only thing that I can look at is retaliation, because I was at every one of those Senate hearings and those House Administration Criminal Justice hearings. I was there. And the only reason that this could be happening is retaliation, and that is simply not who we are. And it should not be who you are. And you people are better people than that. And you just cannot let this happen. Thank you.
Good afternoon. My name is Nathan Fennell. I'm an attorney at the Deason Criminal Justice Reform Center, which is based at the SMU Dedman School of Law. We work on access to counsel issues throughout the country. I'm based here in Louisiana, but our office is based at SMU's campus. And I'm here because we care deeply about public defense and independence, and whether public defender systems have the kind of structural independence that's necessary for the lawyers on the ground to do their jobs effectively and ethically. Multiple people at the center, including myself, have worked in or related to public defense in Louisiana specifically, including our director, Pam Metzger, was on this board on a previous iteration. I want to talk very briefly about the origins of this board, and I promise I'll bring it back to today real quick. So this board started in 2007 with Act 307, right? And it was a series of reforms that were designed to create independence and stability among public defenders. It was designed to improve quality of representation, and at the time, it was considered a national model. Last year, I told you I'd get real quick, back up to here. Last year, the Senate passed SB 8 in the second special session, and that changed some but not all of the statewide oversight structure, right? So it created the Office of the State Public Defender, which Mr. Starnes now runs, and it made the state defender more accountable to the governor directly, and it reconstituted this board to primarily provide oversight over the work of the Office of the State Public Defender. But there were a lot of things that it did not change. So SB 8, when it created this board, it amended portions of 15161. It amended portions of 15162. It amended portions of 15170. What it left in were subsection H1, saying that contracts should be renewed. It left in 162, subsection A, saying that vacancies can only be created in 5 instances. It did not include non-renewal in there. And it left in subsection 170C, which provides the protections that these defenders are asking you to exercise in their terminations today. The legislature could have defined non-renewal. The legislature could have said that these folks could not be renewed at any time with no defense, with no protection, with no oversight by this board. It would have been bad. It would have been against national standards, best practices. It would have not been the right choice. But they could have made that decision, and they didn't do so. The phrase "simply not renewed" was invented by the state public defender. It was not created by the legislature. Under state law, those provisions remain, and so that's just what I wanted to emphasize for the committee today. Thank you so much. Oh, I apologize. Questions? I'm more than happy to answer. Right.
Good afternoon. It's nice to see you again, I guess. I'm Jim Boren. I'm the president of the Louisiana Association of Criminal Defense Lawyers. And the reason that we wanted a recess was to make sure that we all covered all of the points that we want to cover, but that we didn't cover them 5 times. So I'll start with this. When Act 307 was passed, the preamble to Act 307 listed the American Bar Association 10 principles for public defense. And the legislature said, these are the 10 principles that we want to follow in our bill, and we adopt them as the policy of the Louisiana legislature. And that has never changed. And the very first provision under the 10 principles of public defense is independence. Now, independence comes in various ways. One of the things that used to happen, and I'm not sure if any of the committee experienced this, was that the way the public defenders used to be appointed was that the judges did it. The judge said, Mr. Boren, you're the public defender, and I want to move my docket, and I want you to bring people in here, and I want you to resolve cases. And that's not independence. And so one of the very first things that happened was that the judges were removed from the selection of the public defenders. I think some of the judges liked that, and some of them may not have liked that. But that's what happened. And what did happen after that is that people became public defenders who believed in independence and who believed that their job as a public defender was to challenge authority. It could be the judge, it could be the cops, it could be the district attorney. But they had to operate under a system where they could speak the truth in court and where they could advocate on behalf of the most despised citizens of our state, the people who were accused of horrible crimes. And that is what public defenders did, is that they courageously and without fear pursued and insisted that their staff do the same thing. Another form of independence is what we're facing right now. The governor has made no secret of the fact that he would like to see a whole bunch of people on death row killed as quickly as possible. And the Attorney General is more than willing to assist in that. So who is it that defends the people on death row? Who is it that defends the people that the Attorney General and the district attorneys are targeting? It is the public defenders. And how do they do that? They do that because they have money. And because right now they feel like they can do what they need to do. But if the only person who is supervising them and is their boss is one person whose job depends upon remaining in office and pleasing the governor of the state of Louisiana, if that is not independence, that generates fear, and that generates a lack of independence. And that's what we seek to avoid, and that's what the purpose of having a public defender is supposed to be all about. So I don't know if it's a respectful term or not, but you're the watchdogs. You are the people whose job it is to say, if the state public defender is not allowing the independence that we cherish, then you step in. It's not something that you may do, it's something that you must do. It's something that you shall do. And so why are we here? The only thing that these 5 defenders have in common that I can tell is 2 things. Number one, in 2024, they stood before the legislature and the House and the Senate, and they said that the efforts of the state public defender to eliminate all supervision was wrong. And it did not guarantee the independence that they need to operate their offices. And that took great courage. And the result of having great courage is that you also have faced great punishment. For example, the loss of your pension and the loss of a job that you have had for 25 years, 115 years between them. The other thing that they have in common is that they did it again this year. And they testified that this bill that the state public defender sought to have passed, which would have eliminated you completely, was defeated. And it was defeated, I think, I don't know if you have had or will ever look at that testimony, but it was powerful. These are strong lawyers. They're used to advocating, however, on behalf of other people. And today they're advocating on behalf of themselves, but they're really advocating on behalf of a system. And they should be commended for that, not punished and not fired for speaking the truth. The other thing that they have in common, I'm not a civil lawyer, and I don't know, you could call me a civil rights lawyer, but that would be disrespectful to the people who really are civil rights lawyers. But if I see that of a group that size, women are removed from their office and people of color are removed from their office in a disproportionately or at all, that's a suspect, and that's what they also have in common. In fact, Brett Brunson at a board meeting publicly told, you might say scolded, Mr. Starnes for bullying women. And that took courage too. And the day after he did that, he received a notice that his contract would not be renewed. That could be a coincidence, or it could be the clearest, most basest form of retaliation that you could ever encounter. You know, every single one of the lawyers who you have heard from today is someone who I have taught in law school, who I have worked with on cases, who I have participated in training, and who I know. I know their talents, and I know their heart. And they are, they know why they're here, and they are not afraid they're not begging to have something happen. They're saying, we are speaking what is right. Another thing that I have done and Gene Ferry has done is that you try to recruit people to become public defenders and wean and train them to become chief public defenders in their districts. And what you want is you don't want people who want to just go along to get along, whatever the judge wants to do. Well, the DA doesn't like that, or the cops are not going to do this. That's not who you want. You want people who are dedicated lawyers. Now, these guys, you know, I doubt that antitrust is a field that they would be interested in, but they're smart enough to get that kind of a job, and have always been smart enough to get a job that pays you $1,000 an hour for doing the most boring stuff in the history of the world. They didn't choose that. They choose to make something around $40 an hour, if that much, representing poor people who are despised by their community and who are mistreated by the system. Now, how are we going to get that kind of quality person to take a job to replace them or to replace anybody else who speaks up against the public defender if the answer is, well, don't challenge that judge, don't challenge that district attorney, don't challenge that public defender, you'll be fired. And I think it's going to be very difficult to find the quality of lawyers that are being dismissed and to replace them. And so I urge you to, you know, I'll bet when someone said, hey, you want to serve on the public defender board, you know, they meet 4 times a year. All you have to do, right? So I don't know if you're a Peanuts fan or not, but, you know, Lucy did that every year to Charlie Brown. And every year he fell for it, and he kicked the ball, and he fell down. But I'm glad that you're here. I'm glad that you have agreed to hear all of this. And I know you may have some misgivings about accepting this position in the first place, but we are all glad that you did. You're exactly the kind of people that we would want, considering the fate of this system and these people. I'm happy to answer any questions that you might have. Thank you very much for your time and your patience.
If you don't mind. Members of the committee, my name is Jacob Longman, and I have the privilege of representing the 5 district defenders you've already heard from today. And with your permission, in about 5 minutes, I'm going to do my best to beat a horse which, if not dead, is in mortal danger of expiring. I'm going to walk through some of the law real fast, turning first to the question of whether or not you as the board have the supervisory and oversight authority to recommend that these defenders receive a hearing on their non-continuation of a contract. And I submit this. It is incredibly simple. 146B1 specifically says your purpose is supervision and oversight. It says it in plain language. When you look at 161H1, turning to whether or not the district defenders have a right to have their contracts continued, it says they shall continue. It is mandatory language. It is non-permissive. When you look at 162A, it defines what a vacancy means. And nobody is contending that Mr. Storms does not have a right to appoint new people to fill a vacancy. Nor are they contending that under 170C, he has the right to terminate, well, assuming he is acting in good faith, with just cause, any of the district defenders subject to the oversight of this board. Now, what that means is that Mr. Starnes' power to contract and hire is limited to this board's oversight. He's allowed to negotiate the terms inside of that contract. He could change them even under the language, according to the oversight of this board. These compensation plans are a good example. He has the right to modify compensation according to the oversight of this board as he continues the contract of these defenders. But what he cannot do is he cannot terminate it or not continue it without just cause that was found in good faith. Now, I've read the AG's opinion, and I think it is an excellent opinion that discusses one issue on one statute and leaves out a bunch of other statutes that must be read into this issue, including 161 and 162 and 146. I'd also like to point out that it is advisory only, and that in the grand total of the 3 days I had to prepare for this hearing, I've read a lot of law. And I would be remiss not to point out to the board that based on the evidence put forth here today, an AG's advisory opinion has never been held to shield anyone from a discrimination claim or a First Amendment retaliation claim. With the evidence that you have and the evidence that you've seen, based on what you've heard, we'd like to propose that the committee adopt the following stipulations. The following findings of fact and the following findings of law. First, for the facts, we'd like to propose that the committee find that the law is silent on non-renewal. The law says, and we'd also like to propose that the committee find that Mr. Starnes went back to the legislature multiple times in an attempt to circumvent that silence. We'd like to find the committee to find that he introduced 2 bills that were deferred after the legislatures directly pointed this out on the floor. We'd further like them to point out that to this committee that there would be no need for these bills if this committee did not have supervisory and oversight authority already. If you didn't have it, there would be no need for him to be on the floor trying to amend. We'd also like them to find as a stipulation of fact, you to find as a stipulation of fact, that there was no good faith showing for why these contracts aren't being maintained or continued. And we'd like you to make the following conclusions of law. That because of the non-renewal of the contracts with the district defenders is not being addressed in 15-146, you must look at the legislative intent. That the legislative intent, as put forth today in testimony by my clients, is clear that the non-renewal of contracts with district defenders was to be allowed only for just cause and in good faith, with an appeal to this board at the option of the district defenders. That any attempts by the state public defender to not renew the contracts of these 5 district defenders in the absence of good faith showing of any cause is invalid, and therefore the contracts must be continued. And we'd also like you to find that the authority of the state public defender to enter into contracts, including with these district defenders, is not absolute, and that is subject to the oversights and restrictions of this board. And at this time, I'd like to take any questions you have.
I do have a question.
We're about to. I would like to send you copies of these, if you don't mind, these proposed findings. Just for the record.
I don't know that we have, oh, we got somebody.
And here's one for each of them, if you don't mind. What's up?
They want you to clarify that. Thank you.
Members of the committee, my clients have handed me a note that they would like me to clarify that, as I'm sure you're aware, that the board sets the compensation scheme. What I meant to say is that Mr. Starnes has the right to negotiate within what the board says.
For that clarification.
Yeah.
To your knowledge, since the committee first convened on these issues, are you aware of any negative audits or site visit or reports, anything that would give any credence or any support to any sort of cause for these, I'll call them failure to continue a contract?
No, I'm not. Not to my knowledge. And I asked my clients that over the last couple of days as I got up to speed on the case, and they don't have anything either.
Okay, thank you.
Well, and to go along with that, vacancies can be the result of demotion, according to other, and also termination or retirement. Are you aware of any attempts or the beginnings of any demotion attempts of any of the five that you represent?
No, I'm not.
All right, thank you.
Thank you for your time.
Do you have any other words you'd like to speak on behalf of the board?
I'm just arm candy for Mr. Longman today.
Which I should point out is usually the opposite of the way it works. I think I'm just there to make her look good 9 times out of 10. No, at this time, there's nothing else we'd like to put on here.
Anyone from the State Defender's Office who would like to speak? Nothing, I assume there's no. Is there anything, any committee members would like to? It was complained that we didn't speak to each other in public last time. So anything of it?
I would like to say, and I don't know what's going to happen after today. I think we will do our best to do the job that we see that's put before us. But I would like to say that as a final point, the five of you were never given any negative reviews, negative site observations, negative audits. And to me, that speaks volumes. On behalf of the public, I'm a member of the public. I would say thank you for your dedication to your jobs, whether you worked for 2 months or 3 months or what have you. And I know that each of you have been in your positions for longer than that. I think it's noteworthy to put on the record that clearly you have not been doing a terrible job, and it's a lot of work. I understand the pay isn't always comparable to the hours that you're putting in. It's not a job for all of us. I wouldn't do it, honestly. I care about people, but I don't practice criminal law either. So, but I just wanted to put that on the record. And I think, however things turn out and whether we have an opportunity to speak with you all again, I wanted you all to know that.
All right. Complicated display of the attorney. There you go. I'd like to point out that Mr. Starnes, no representative of Mr. Starnes appeared here today. In our, I don't know if we can take notice of it, but in our previous proceedings, Mr. Starnes has not given any statement of cause for the action of he took in not renewing contracts. What I see as the main question is does the law envision non-renewal of a contract as being requiring cause? And initially, based on our previous hearings, it was my feeling that non-renewal contract did not require cause. However, the arguments made today referring to the statutes, and it somewhat changed my opinion. And the only question I have right now is, there was a complaint before about us discussing the matters privately and not in public, before the public. So I'll ask that we not make that mistake again. And if either you would like to speak regarding your feelings or your decision, please do so.
My only experience with criminal defense and even criminal prosecution was on the bench and as a judge in district court. I will say that several times, even as a judge in district court, I would get briefs and arguments where the attorneys neglected to expose the law that was opposed to their position. And I think that that's kind of happened here, that unfortunately we were focusing on a very narrow question from the Attorney General's office, and should not have been limited to just that area of or that part of the statute or the laws that apply in this position. And today, I've been made aware of some areas of the law that Mr. Starnes neglected to show me. And this has happened before. It's not unique just to this. Sometimes attorneys think that if the judge doesn't hear the opposing side, they won't look into it. But what we've done today is look into it, and I appreciate your testimonies. Thank you.
I will say, when we first convened, that our focus was, as Judge Demai said, it was a little different. The act under which the committee was created, right, was enacted or put into play. The first part of it is, was there a trigger with someone claiming that they were terminated? So then after that, our first question that we reviewed, and I'll just kind of speak on behalf of, in a way of a recap of our original committee meeting, we were looking at whether or not a termination actually occurred, but looking at it really in a bubble of contract law. Okay, so I do remember very clearly a couple of members of the committee asking the state to produce any evidence of any sort of audits, any sort of site observations, anything that would give us further information to determine whether or not this was related to what's being termed as a termination. Now, once we asked ourselves and based on the information we had before us at the time, whether or not a termination had occurred, we came to this conclusion that it was, in the context of contract law, that this was simply just a non-renewal. today, I echo what my cohorts have said. Today, the supplemental information that we were allowed to review for this part 2 of the committee hearing, I think gave me a much bigger breadth of understanding as to specifically the legislator's intent, and also pointing out a very big void in terms of any real language speaking towards the concept of non-renewal. That was something that we didn't really look at, didn't really see, didn't kind of missed it, but obviously it came back up very, very clearly with the 2 bills that you all have spoken about today and presented your supplemental information. It came up in a very clear way for me in the sense that the terminology was attempted to be added to the law because it was absent. And I can't disagree with the fact that if the law is silent on something, then you go to their legislative intent, okay? And then the second part, contract law, if it's contradictory to the state law, is never going to fly. With those points together, for me, I'm at a different conclusion. And I'm one of those people that when I feel like I've looked at something incorrectly, I'm going to be the first to say on further review or further consideration, or et cetera, this is my different appreciation, and I think this is one of those instances.
There it is. Okay, I'd just like to point out that what my experience has been as a public defender. When I got out of law school, every lawyer had to volunteer to be appointed. But within a couple of years, that didn't work too well, so every lawyer who practiced law had to be appointed, had to be subject to appointment, and I did both of those. And then finally, the legislature decided this system doesn't work real well. We need to fund, put some money into it. And then at that time, I became the chief public defender of my district, the 16th JDC, and held that position until I got elected judge. And at that point, it's kind of necessary for me to give that up. So I served about, 13 years as a public defender. And it was, in our previous decision, I felt compelled to make that decision even though I didn't want to. However, since what has been presented since then has changed my mind. And I think that the state defender required cause for non-renewal of their contracts. And at our last hearing, he specifically stated that he didn't have to, he refused to give any cause. And of course, he's not here today. So that leads me to believe that he is unable to produce cause for failing to renew contracts of all of the individuals involved. So at this time, I guess we need to, although we've expressed our opinions, we need to take a vote as to what action to take. And I believe the question is whether to affirm the decision of the the earlier committee, or reverse it.
I vote to reverse.
I vote to reverse as well.
It's unanimous. I vote to reverse. Now, if somebody's quite familiar with the procedure, what do we do next?
I guess we present it to the board.
Yeah, we have
Monday.
to reduce it to writing, I think.
Okay.
Present it to the board
And present it to the board Monday.
for
It has to be-
approval
yeah.
or denial,
Okay.
or modification.
So I'll draft something and send it to y'all, see if y'all agree, and then and present it to the full board. Now, procedurally, do we need to send them that before we have the meeting, or present it at the meeting?
Before the meeting.
Before the meeting.
They know.
Okay.
Ms. Ferrier knows the procedure. You know the procedure?
Okay, let's do this. I think this is not necessary for the actual meeting, so let's declare the meeting adjourned, and we'll get some guidance.
Thank you all.
Okay.